Ever wondered if you really need a power of attorney, a living will, and a last will and testament? We'll tell you the surprising truth on Toronto Speaks Legal Advice. Welcome to Toronto Speaks Legal Advice. I'm your host, Natalka Falcomer. Tonight we're discussing why you or a loved one needs a will, power of attorney, or power of attorney rather, for property and personal care, as well as a living will. And it's true, only if you have $100 in your bank account. Tonight, I'd like to welcome on Tony Baker. Tony not only sits as an adjudicator and presiding lawyer on the Consent and Capacity Board, but he's also been a big teacher of negotiations, and he also mediates. He's taught at various post-secondary schools, and as well, he's actively engaged in providing a lot of advice with respect to the wills and testaments area that we'll be talking tonight about. So again, thank you. Welcome, Tony, again.
Thank you.
And thank you for coming on today.
Thank you.
What is it? How many times have you been on?
I think this is the fourth time.
The fourth time.
Yeah.
And every single time, you blow my mind with how it works. You know, so let's start with the very first question that we ruled with. Okay, power of attorney, personal care, continued power of attorney for property, you know, last will and testament. My gosh, a living will? Do I really need all these things? And let's just start from the top. What's the difference between all of them?
Okay, so my opinion is that yes, you do need all three of those documents: a power of attorney for personal care, a continuing power of attorney for property, and a last will and testament.
And a living will?
A living will is a portion of the power of attorney for personal care.
Got it. Okay.
So if I were Premier of Ontario, I would pass a law that said that everybody must have all three of those documents. If it was like OHIP for lawyers, we could do something like that. Unfortunately, in Ontario and in all of Canada, there's legal aid, so there's some payment of lawyers, but generally speaking, it's a private business, the practice of law, and clients have to pay money. So it's a cost-benefit analysis, and you basically have to pay for each of those documents. Lawyers are all negotiable. My fee's $400 to do a will, $200 to do a power of attorney, and I recommend that if you do them all once, they should be good for the rest of your life. If you lead the life that most people lead.
Oh, that's interesting. I think there's a lot of stories behind that one. But you're saying that you would think that we should always have the power of attorney for personal care. Well, what about this attitude? I don't think so. I'm healthy, I'm fine. And also, you know what, if something happens, I know my kids, my spouse, my wife, my husband, my mom, my dad will know what to do. What's your thought on that? If someone were to say that to you, I wouldn't worry about it.
Well, I would pose a scenario which would contradict that idea. So let's say, God forbid, you're in a car accident and you're bleeding to death at the hospital and you are in a coma. And you have one child who shows up at the hospital, and you have a spouse, a wife, a second wife, showing up at the hospital arguing about what the doctor should be doing in order to keep you alive, or to, depending on your religious beliefs, if you're a Jehovah's Witness, you don't believe in blood transfusions, the doctor has to take instructions from somebody. So the law is the doctor can't touch you without your consent. And if you're incapable of giving that consent, they have to go to a substitute decision maker. And if you have different people in the same class, for instance, two different children arguing about the kind of care you should be getting, the doctor's in a dilemma, because if he picks one, the other's going to be unhappy. If he picks the other, the first one's going to be unhappy, as to if they have, like a Jehovah's Witness is a good example, if they don't believe in blood transfusions. If it's laid out in writing, you've appointed a substitute decision maker, whether it's your child or a friend or whomever you've appointed that's who the doctor has to go to.
Do
So
they have
it's
to
certain.
know that they were? Sorry, one second. Do they have to know that they were appointed, and would they sign the agreement as well? So, for example, I say, Tony, I trust you. I know that you're going to do the right thing. These are things I want you to do. Can you say, sorry, not into it, not interested?
No, you can. So a donor, as they're called in a power of attorney, can appoint any attorney they like, but the attorney can always renounce his or her appointment. So you can't be forced to be an attorney under a power of attorney for personal care or property. So usually, I mean, when clients come to see me and we do the first draft and they tell me who they want, I say make sure that they know about this and they consent to it ahead of time, because you don't want to go down the road and have them renounce after you've already done the power of attorney.
Do you want them to sign a separate document?
Not necessarily.
Okay.
No.
Just so that they know.
No, because they could change their mind. They could say today, yes, I will be the attorney, and then down the road, for whatever reasons, they could choose not to.
You know, actually, let's first cover exactly what a power of attorney for personal care would cover.
Okay.
And then I want to ask some questions about if you recommend having more than one attorney on there. But we'll first start with, what does it cover exactly besides just straight health or what have you?
Okay, so the old days there was just what was called a power of attorney, and now that's referred to as a continuing power of attorney for property. The property is personal property, so bank accounts, mortgages, anything that you own personally in a power of attorney for property, the attorney can sign on your behalf. Mm-hmm. And that's so lawyers are more concerned with powers of attorney for property. Powers of attorney for personal care are relatively new, and they came into being in the 1990s. The Substitute Decisions Act set out the criteria for having a power of attorney for personal care, where you could appoint somebody to make health care decisions on your behalf. So it only relates to personal care, health care decisions, not property decisions. Mm-hmm. So that's the one I say that the doctors are more concerned about. So all my doctor friends say when clients come in, make sure they do power of attorney for personal care. Yep. And then the lawyers like the power of attorney for property, because nowadays a lot of people live to be, like I have clients who are over 100 years old, and their heart's beating fine and their body's chugging along, but they may have Alzheimer's or they may have some sort of dementia, and they have good days and bad days. And if there's a power of attorney for property in place, mm-hmm. and they're living in a house that has a leaky roof, and they have a concerned child who may be an attorney under power of attorney for property, that child could go and fix the roof, do whatever they want to do, as long as it's for the benefit of, in this case, their mother, if it's a child who's the attorney. So as long as it's not them profiting personally, as long as the reason that they're spending the money is for the best interests of the donor, the person who originally gave the attorney the power to act on their behalf, they can go ahead and do that. Whereas most people are aware of a will, and so if you have a dividing line with our lives, and on this side of the line we're alive, that's the realm of the powers of attorney, mm-hmm. and on the other side, after you're gone and passed away, that's the realm of the will. But you can't look to what the will says until after the person that made it is gone.
Right, that's why it's not effective. Too bad, so sad.
That's right.
Now, a question that you always hear come up is, okay, so I'm nervous to sign this power of attorney, for personal care or for property, because then that kid or that friend or whatever, they're going to be able to use it right away.
You can limit it, but I don't recommend that. The most important thing when you're doing these powers of attorney is the person that you're appointing trustworthy? Do you trust them? Not, are they rocket scientists? Are they financial wizards? Are they the smartest kid in the class? It's, do you trust them? Mm-hmm. And if you trust them to only act in your best interests, it's best not to limit the attorney, the power of attorney for property or for personal care. It's best to leave it unbridled, giving them wide discretion to do whatever they think they must do on your behalf. Mm-hmm, mm-hmm. That's my advice. Now,
but when does it kick in?
Well, it kicks in immediately now. So that, for instance, that's the danger of them. That's why you want to appoint somebody who you trust. So I have situations where I have a mother who will have a son who she dotes on and appoints to be her attorney, and she doesn't know that he's got a gambling habit or a drug habit or a drinking habit, and she gives him this power of attorney for property, and lo and behold,
And she's not incapacitated.
No.
She's got all her mental
she's
faculties.
got all her mental faculties. Lo and behold, he cleans out her bank account, because once that person has the power of attorney for property, they can take it anywhere. They can take it to the banks, they can take it to financial institutions, and the banks don't have to make any inquiries. They can look at it, and on its face, if it says they have the right to do what they can do, they can accept it. So it can backfire, and if they can be abused. That's why it's so important not to give them out unless you trust the person.
Could you feasibly set one up, give it to your lawyer, saying, look, I don't want my kids to know that they have power of attorney, for a property just yet. I'm fine, I'm healthy, I'm a 40-year-old, for example,
Right.
or what have you, or a 56-year-old. Could you hold on to it? And my instruction to you would be, look, if I become, mentally incapacitated, then you let them know. Is that a good way to manage that?
I personally wouldn't want to do that, because I may not know if you're incapacitated. I mean, I have clients that come in and they do their wills 15 years ago, and I never see them again because they live in the same house, they don't have no need for a lawyer, and then I pick up the paper one day and just happen to read they've passed away. I would have no idea if they have Alzheimer's or if they really need somebody to act on their behalf. I don't recommend it. I recommend you do. The key is you appoint somebody that you implicitly trust. You tell them that you've appointed them. You tell them where the original powers of attorney are, if they're in your safety deposit box or if they're at home somewhere. And you say, if you need to use these, this is where they are.
Okay.
I think that's the best approach.
Okay, so limiting it could cause a whole lot of factors that are problematic.
An example of when I've used limited ones is if I have a client who's buying a property and they happen to be in Italy when the deal closes. So they can't sign that day, and they want me to act on their behalf. I'll limit it. So they'll appoint me to be the attorney, and then we put in a clause, provided it's only for this particular real estate and it expires the day after closing. So you can limit them. But for an ongoing continuing power of attorney for property, most of my clients, so my office is on the Danforth. I have a clientele that's in Riverdale, and it's like a general practice. And I have many clients. They've only been married once, they have children, and they go through their life, and when they die, they're still married to the same person they've been married to all these years, and their children have grown up.
They haven't moved.
They haven't moved. And there's no need to change their will or the power of attorney for property. And I would look, and it's been drafted 20 years ago, and it's still quite valid and useful. I mean, if there's been a divorce or there's been a major change in a life event, then you might want to revisit it. But for most people, it's something that you can do once, and you don't have to look at it again for years.
What actually would be some major changes? So we hear this, and I see this often. We were talking about it just before we started filming, that there are a lot of scenarios now where grandpa's still around, grandma had passed away, grandpa finds a nice young lady starts to get involved, grandpa passes away. Now there's questions as to who gets what. So how do we manage that from happening? She's, let's say, taken care of him for 8 years and so on, and she feels that she's entitled to something, but the will hasn't changed. How would we manage that, or what would happen in that scenario from a legal perspective, and what would be a solution?
Well, we always start with the first principle. If there is a will, we look and see what the will says. So let's say somebody did a will years ago and they appointed their wife, and then their wife happened to die, and in moved the younger, more ambitious second.
I like that word.
Common law, as we say, partner or spouse, and these words can cause confusion because if they're not married, they're not a wife legally. So if you are a wife, you have certain claims, or if you're a husband, you have certain claims to property division. The common law gives you all sorts of rights, and we don't want to get too far into family law here, but if you are a partner, a spouse, somebody who's not legally married, you can make a claim against the estate if you feel you've contributed, but it gets a little bit complicated. If you remember in law school, we talked about
Everything's complicated in law school.
but there was the big division in the old courts between the common law courts and the courts of equity, the chancery courts. So the common law courts have been around the longest. The common law is kind of the big stick, but there have grown up these doctrines in equity, they're called, where you can make equitable claims against an estate. So the whole law of trusts is filled with equity, and people can make claims. It's called a resulting trust or a constructive trust, where in this case, if you know the older fellow wasn't really doing a lot of work around the house and his younger partner was contributing sweat equity, we'll say, and she was working hard and she was painting and she was helping him fix the place up, she could make a claim against the estate in this realm of constructive trust or resulting trust, but it's more of an uphill battle.
Yes.
You know, if the elder fellow is competent and he wants to change his will, much to the chagrin of his children who don't want him to leave more to the new girlfriend, I always say to the elder fellow, you know, you're my client, not your children.
Yeah.
And I mean, you can leave everything to the Red Cross if you like. There's no law that says you have to leave everything to your children. It's your last will and testament. It's up to you and your conscience where you want to leave it to. We look at the will. We start with that. If somebody doesn't like the terms of the will, they're free to make a claim in trust, you know, in the law of equity. But it's an uphill battle, and it's often not successful.
Who often is the one who's allowed to make a claim? Is it just, let's say I'm a cousin and my uncle passes away, and I feel, for some reason, unless there's no real connection, I deserve a piece of that estate.
Tough luck. If it's not in the will, I mean,
like, how far does it extend to random people saying,
if you're not in the will, I mean, the common law courts have given great credence to wills through the ages, and they put great faith in what a person who's capable puts down as their last will and testament, and they don't deviate from it. I mean, there's a lot of myths out there that, oh, you just make a run at the estate and you're going to get something. You may get something because a lot of lawyers will say there's a nuisance value to any lawsuit. So sometimes they'll say it's going to cost us $20,000, $30,000 to fight this in court. Just give them $5,000 to make them go away.
Yeah.
And that quite often happens. But that's not because of the law. That's because of the expense of lawyers and what it costs to litigate these days. The only valid claims you can make against an estate in Ontario, and remember, it's important that this is Ontario specific. So in Canada, we have, you know, cooperative federalism, and property and civil rights under the old Section 92 of the British North America Act gives the provinces the right in property and civil rights.
Yep.
So wills and estates falls under that jurisdiction. So people will be watching television and they don't know that they're watching a show that's taped in Vancouver or it's taped in Halifax.
or in America for that matter.
Or in the States, and they're talking about something. Remember, you have to take all that with a grain of salt. If it's not Ontario, it's not Ontario law. So in Ontario, there is an act called the Dependents Relief Act. So if you've got a child who's dependent upon you, let's say they're disabled and you've been looking after them for years, and you cut them out of your will, you leave everything to the Canadian Cancer Society, and you don't provide for that child, they could make a claim under the Dependents Relief Act.
What would I have to prove, though?
You have to prove that you were dependent upon the deceased and the deceased was providing dependence relief for you at the time of his or her death. And again, these things all have to be proven, and it's uphill. So dependence relief is probably one of the only, you know, legitimate claims you can make against a will if you're not named in it and the will was properly executed.
Well, what about, just one question on the Dependencies Act, would age matter at all?
No.
Okay, so that's something that is not really taken into consideration, but otherwise it's quite rock solid.
Yeah.
You know, we always talk about being taxed, you know, and the value of the estate and what to do and so on. And you hear this word probate being thrown around in that. What does probate have to do with the will?
Okay, so probate is a Latin term and it comes from proving, so proving the will. Letters probate was the old Latin term that the courts used to use, and now we're not supposed to use Latin in Ontario. We're supposed to, as lawyers, use plain English. So now lawyers will all say we have to go through the probate process. What that means is the lawyer has to apply to the estates court to get what's called a certificate of appointment of estate trustee.
That's a mouthful. It was something else before, wasn't it?
It was either, if there was a will involved, it was called letters probate.
Yep.
And if you died without a will, it was called letters of administration. Now it's a certificate of appointment of estate trustee with a will, or a certificate of appointment of estate trustee without a will.
Another mouthful.
Another mouthful. So we have to apply to the estates court to get that 95% of the time. Sometimes you can administer an entire estate without going through the probate process.
Why is that?
Well, if all you've got is a bank account and the bank manager's known you for many years and they're happy to look at the will and they know the child who's the beneficiary under the will, they may be willing to take the risk and pay out whatever was in the deceased's bank accounts.
But if that's not accurate, it would come back on the bank, wouldn't it?
It would come back on the bank. And so the banks nowadays, most institutions won't take that risk, and the only fail-safe way for them to avoid the risk is to insist on a court document which shows that the estate trustee, who used to be called the executor if it was a will, has the valid authority, and that valid authority is the certificate of appointment of estate trustee.
Now, what does the executor do? Does it cost him or her money? Can there be more than one person on there? What do they do?
So it depends on, again, you look at the will, and if the will appoints one estate trustee or executor, then it's up to that person to apply. If the will appoints two, they have to be co-estate trustees rather than in powers of attorney, you can name them jointly and severally, which means one or both. But if there's two named, both of them have to apply.
And both have to be in agreement with how things move on?
Well, that can be a problem.
Yes,
so that's why I don't usually recommend having co-estate trustees. I usually recommend you have one, and if that one can't, then you appoint an alternate. If that one can't, you have another alternate. So you go down the chain of command. And it's up to the executor, estate trustee. Those are synonymous terms. They mean the same thing. It's up to them to apply to the estates court and pay the fee, which is 1.5% of the value. So they have to, first of all, determine what the entire value of the estate is. Real estate, bank accounts, stocks, bonds, mutual funds. What does it add up to? It's approximately 1.5%. It's a little nuanced, but basically 1.5%. So on $1 million estate, it would be $15,000. That's what the so-called probate fee is. It's now called an estate administration tax fee is. They have to pay that.
And it's always a flat fee like that?
Yes, it's a percentage of the value of the estate. And then once they get the certificate of appointment, then they can start distributing the assets as set out in the will and selling the real estate, cashing in the stocks, bonds, etc., distributing them according to what the terms of the will say.
Well, that sounds very complex. Can they hire someone, and who pays for that?
They can. So I always tell people that even though I'm a lawyer and I derive most of my income as a lawyer, I also do work as an estate trustee. And if they want me to be an estate trustee in their will, I'm happy to be appointed. If not, I'm happy not to be appointed. I've had situations where the people who are appointed start off doing the work and then they find out it's just too much for them and they throw up their hands and they ask if I'll take over, and I will, but I'm going to have to get paid according to the there's a tariff it's a ballpark, but it's generally agreed that the executors of an estate in Ontario are entitled to about 5% of the value of the estate. So if it's a $100,000 estate, the executor's fee is about $5,000. And depending if I got involved in something like that and the estate trustee had done, we agreed she'd done half the work, then I would charge, and it was a $100,000 estate, I'd charge $2,500 to do it, and then I would wind it up. Because lawyers are set up to do it all. We've got all the software. We've got,
What software would you need?
Well, just, you've got your spreadsheets, you've got your accounting software, you've got, the forms that the courts require, notarial seals to do all of the documents that the banks require. So it's generally easier to churn it out of a law office than it is if you're struggling at home and you've never done it before.
Well,
I mean, you can do it, but it's just easier.
Well, in fact, I know there's someone who regretted his decision to do it by himself. gravely. Didn't realize how much work it would be, how much frustration, how technical it would get. And he said, I wish I had not done it on my own. It is a complex thing to do, and even simple estates can be quite complex as you're involved in a lot of different government bodies that require certain things to be done in a particular way.
Right.
We have a few minutes left,
Okay.
and I want to make sure that we covered a couple of things. I die without a will. What happens to my assets?
You die, that's called, you die intestate, so, which means you don't have a will. So there's a law for everything. As you remember in law school, wherever we go, there's law. It fills every gap. And if you die without a will, the Succession Law Reform Act of Ontario fills the gap, and it dictates where everything goes. So in Ontario, the first $200,000 of your estate goes to your spouse, wife, husband.
Well, let's say I don't have anyone.
Then it would go.
eHarmony didn't work.
Then it would go. It's all set out according to the table of consanguinity, which shows. So if you're not married, but you've got children, it goes to your children. If you're not married and you have no children, it goes to your parents. If your parents are gone and you have no children, it would go to your brothers and sisters. If your brothers and sisters are gone and they had children, it would go to your nieces and nephews. So it's kind of like water flowing, following the bloodlines. You basically follow the bloodlines out. And I mean, I've been doing this since 1982, and I've never had an estate where somebody died with or without a will, where we didn't find all of the heirs at the end of the day. There's always somebody. There's a second cousin in Scotland that gets a surprising letter in the mail and says, you're the sole heir of this.
I have to know.
It happens.
We all dream of that one day that that uncle that we never knew we had. I know we're the last remaining survivor. We have a couple seconds left. What's the craziest thing you've seen in that context? Have you seen that happen?
The craziest thing I've seen is I had, she was, I guess, she was an aunt's daughter who had no idea that this person who died here in Toronto actually had a fair amount of money. It was about $400,000, and she inherited the whole thing, $400,000 in Scotland. Yeah.
Wow. You see, so better to have a will in place, but the law does touch everything. So of course, as we wrap up, I have to say that it's important to get a lawyer involved. And that's the rule that we should put forward. And Tony, thank you so much for coming on today.
My pleasure. Thanks for having me.
There was a short talk, but it's all the time that we do have today. I want to thank our viewers at home for watching and for being a dedicated audience. Again, thank you, Tony, for your help and for making sense of the law. Remember, know your rights. And if you don't, then watch us next time to get free legal information. After all, the best things in life are free. I'm your host, Natalka Falcomer, and thank you for watching Toronto Speaks Legal Advice.